Are you going through a military divorce in Texas and feeling anxious about the retirement division? It's one of the most stressful and confusing parts of a military family's divorce, and it's completely understandable to worry about protecting your financial future, whether you're the service member or the spouse. You've likely heard about the 10-10 rule, and you need to know exactly what it means for your military retirement pay in a Texas court. Now let's be crystal clear right up front. The 10-10 rule does not determine whether or not your military retirement is divisible. It only determines who sends the payment. In Texas, military retirement benefits earned during the marriage are considered community property, which means a state court has the authority to divide that marital portion regardless of how long you were married. The confusion comes in because the federal law, called the Uniformed Services Former Spouses Protection Act, introduces this 10-10 standard. Here's the simple breakdown. The rule states that if the marriage lasted for at least 10 years that overlapped with at least 10 years of creditable military service, the Defense Finance and Accounting Service, or DFAS, will send the former spouse's awarded portion directly to them. This direct payment from DFAS is a significant benefit for the former spouse, as it eliminates the need for them to rely on the service member to forward the funds every month, thereby adding reliability and enforcement power. It is also a benefit to the service member because it eliminates any disputes over whether or not the money was sent on time, and it simplifies for tax reporting purposes who should pay the income tax for that income. If you don't meet that 10-year overlap requirement, the Texas court can absolutely still award the former spouse a portion of the retirement, but DFAS will not pay it directly. Instead, the entire retirement check goes to the service member, and the service member is then responsible for paying the former spouse their share directly, which can sometimes lead to complications and the need for future enforcement. In every Texas divorce case, the court calculates the marital share, that portion earned during the marriage, and then typically divides the marital share 50-50 using a specific formula. The divorce decree must be carefully drafted to follow the federal rules on military retirement division and specify the exact percentage awarded, often called a frozen benefit rule calculation, which protects the service member's post-divorce earnings from being included in the spouse's share. Both Texas law on community property and federal law under USFSPA apply, and although the marital share is usually divided 50-50, the Texas court is not required to divide it equally. Therefore, the military retirement division is incredibly complex, and getting it wrong in the divorce decree can have massive, irreversible financial consequences down the line, regardless of whether you meet the 10-10 criteria or not. If you are facing a military divorce in Texas, please don't leave your retirement, one of your most valuable assets, up to chance or guesswork. The details of the 10-10 rule and the required language in your court order are too important to navigate alone, so call South Texas Family Law today for a consultation so we can custom tailor a strategy to protect your financial security, because you deserve clarity and peace of mind during this difficult process.